Lori. Oh my goodness, we have got a lot to talk about today. Jury selection is complete. We have our jury for Lori Vallow Daybell's trial for the murder of her fourth husband, Charles Vallow. How important really is jury selection in the whole scheme of things? Well, I can tell you this. It's very important. I've served on a couple of jurors. Well, I didn't serve. I was called in for jury duty. I think I've been called in 3 times now, and I never did I actually serve on a jury, but I can tell you this, that first impressions and spending the day in a courtroom to find out if you're going to be a juror, I had a lot of thoughts. Let's just say that. I didn't end up on the jury, so I don't know how the outcome could have been, but I will say first impressions are very important. Today, we're going to dive in deep onto how things went for Lori during her jury selection process. I will say first impressions are very important. I have a brother who's an attorney. He's done a lot of different trials, and I keep on asking him, tell me about your opinion about this or that. And one of the biggest things he always tells me is getting it right on jury selection. Getting it right on jury selection. It doesn't matter how prepared you are, what your case is. If you don't get the right jurors, it's going to be tough. So let's talk about why the jury selection is so important. First of all, jury selection in a courtroom is a crucial part of the trial process where both the defense and prosecution have the opportunity to question the potential jurors to ensure they can be impartial and make decisions based solely on the evidence presented during the trial. The goal is to select a fair and unbiased jury that can objectively evaluate the case. Here's how it generally works. Voir dire, V-O-I-R, dire process is the process where attorneys and sometimes the judge asks potential jurors questions to determine if they have any biases or preconceived notions that would prevent them from being fair. This can include questions about their background, their personal beliefs, prior knowledge of the case, and whether they have any potential conflicts of interest. Both the prosecution and the defense get the chance to challenge jurors, either for cause, like if they have bias or prejudice, or they also have a limited number of challenges, each the prosecution and defense, and they can pull those any time they want to for no apparent reason, but they're limited. The goal is to select jurors who will approach the case with an open mind and a commitment to weighing the evidence fairly. So here's the challenge for Lori. When you are self-representing, you're already giving an impression when you're just going to select jurors. I mean, when a person is representing themselves in court, the jury selection process can be much more complicated. Typically, defense attorneys know the importance of jury selection and can use their experience to ask strategic questions, assess body language, and ensure the jury won't be swayed by irrelevant or prejudicial factors. How much of this does Lori know? I don't know. Lori Vallow Daybell is an example of a defendant whose choice to represent herself in her high-profile trial has made jury selection much more difficult. In her case, her narcissistic tendencies, often demonstrated through her behavior in court, could cause major issues for both the selection process and her ability to navigate it effectively. I mean, let's face it, the lack of knowledge alone is substantial. In typical jury selection, defense attorneys are skilled at questioning jurors in ways that uncover biases while building rapport with the panel. But Lori, representing herself, she could struggle with phrasing questions effectively or understanding the nuanced legal questions necessary to disqualify potential jurors.
We thought the jury selection process would take a week, and it actually was done in 2 days. Lori actually didn't ask very many questions, and she made a few mistakes, which, okay, she doesn't understand it all, but did she do enough?
Let me give you an example. In her case, if she were trying to ask jurors about their feelings towards motherhood or parenting, themes central to her charges, she might fail to do so in a way that truly uncovers bias.
She didn't really ask any of these types of questions, so I'm guessing she's just going with her gut? I don't know.
And then there's the way she does emotional manipulation, like she did with Dateline.
She came in like she was on a pageant walk and happy as can be, never showing any remorse for what she's already been convicted of. And I do think that her behavior, knowing that her children were already dead and she's in Hawaii having a lovely time with her fifth husband, Chad Daybell, says a lot about her, as you can imagine. Then when the bodies were found in the backyard of Chad Daybell's house, what's she gonna say? Certainly nothing about being sad or anything, but basically the blame game in an arrogant, crazy way.
I'm in trial coming up, as you know. Do you know that, Keith?
Who would possibly talk like that when she's been convicted of the murders? Her husband's been convicted as well, is on death row.
You did not kill a soul.
Absolutely not.
You didn't participate in killing a soul.
No.
You didn't conspire to kill a soul.
Correct.
You didn't do any of those things you've been convicted of doing.
Correct.
Lori Vallow, as unrepentant as ever, as she prepares to face justice again.
Are you keeping track?
Oh, yeah, I'm keeping track.
The narcissistic defendant will be prone to emotional outbursts.
Well, for 5 years, of course, he's been on the witness list to be a regular detective, and now he's being put on as an expert. I feel like to give his opinion instead of just stating the facts. So that was my main concern. Whatever they're, I don't know, planning on testifying about. None of them have personal knowledge of any kind of crime. He's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that most likely we're having an affidavit sent over from Mr. Dworkin tonight. He has found me information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away, being issued currently. The state talks about in their response, like the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dworkin. His testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not gonna let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give.
State where I am and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did. I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say...
And I shouldn't be able to represent myself because of that fact? That negates my constitutional right?
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want.
A narcissistic defendant will be prone to emotional outbursts or self-centered behavior and could unintentionally alienate potential jurors. Her actions and speech could inadvertently come off as manipulative or off-putting, even if she doesn't intend to project those qualities. Jurors are carefully scrutinizing, not just for their biases, but also for their reactions to the defendant. If Lori were to display arrogance or disregard for the court's process, which are common traits in narcissistic personalities, it could create an atmosphere where jurors already perceive her as guilty or untrustworthy. And realistically, how well is she at reading jurors? I personally think it's probably not that good. And let me give you an example why. On her list of witnesses that she has, defense witnesses, none of them will do it willingly. Her own parents, her own nephews, her sister, not any of them are willing to go and be a defense witness for her in her trial. They won't even reply to phone calls. And as we know, she hasn't arranged anything with them. So, yeah. But yet, in her mind, during court, she's like, well, if I could just call them, they would come. I know they would. I think they'd take my call.
I understand that, and I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them. But I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So
I know they would. I think they'd take my call. She does not understand where they're at. And that's what narcissistic people do. They misread a room sometimes. I'm just saying. But let's face it, if you have an attorney who's a professional, they can adjust their line of questioning based on these cues, making sure to focus on the areas that identify jurors' preconceptions or opinions about the case. The other big issue with representing yourself is that you lack objectivity. Self-representation often leads to emotional bias, especially for a defendant like Lori, whose personal beliefs and feelings about the case may cloud her judgment. Remember, she's got this religiosity, mental illness, where she believes all these crazy out there things, and that's going to cloud up when you're talking to a juror. I'm guessing that religiosity could really cloud the opinions, let's just say that. And narcissists can often have difficulty accepting responsibility, which we know she doesn't accept any responsibility. And this could come through jury selection, making potential jurors uneasy about her ability to present her case fairly. Let me give you an example. If Lori were to argue that jurors should be sympathetic to her situation or use personal stories about her children inappropriately during the voir dire, it could cause jurors to feel that she is manipulating their emotions, damaging her chances of getting an impartial jury. There's increased likelihood of mistakes. In a complex case, mistakes during jury selection can lead to serious long-term consequences for the trial. Lori might overlook crucial legal rules about jury selection, which she does not understand the rules. That is very evident in her hearings.
When Lori started her questioning to the jurors, she started off by trying to introduce herself, and the judge had to say, no. That's not what this is about. You don't have a platform to introduce yourself. This is you asking questions.
She thinks she's the smartest person in the room, but she doesn't understand the basic rules. And I think it was interesting when the judge had to repeat something. He's like, I've already told you 5 times. I'm not going to tell you again. Like, she doesn't understand.
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So why are we waiting until March to address this if you had an issue with that?
I have had an issue with it the whole time. I've
So
been
why didn't you why didn't someone file a motion back in after, December, November, January, February, saying they had an issue with this?
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Well, now you're saying it arises to prosecutorial misconduct.
It is.
This is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through regarding that.
Which is what?
I'm not going to give you legal advice.
It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only 2 parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it, and you're just taking her word for it like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom? I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can interview
interviews
him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
not a witness anymore because you just precluded him?
All right. You can interview him. You can have your investigator interview him.
So even though he's not a noticed witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Interesting when the judge had to repeat something. He's like, I've already told you 5 times. I'm not going to tell you again. Like, she doesn't understand. Or if she does, I don't know, she might be trying to manipulate. Nonetheless, she's argumentative and okay. Let's get back to it. If she inadvertently accuses jurors who are biased or fails to effectively challenge a juror, it can weaken her defense and make it more difficult for her later to argue that her trial was fair. A juror with prior strong opinions about the case, like a personal bias against mothers who lose custody of their children, could be seated if Lori fails to recognize that bias and remove them during voir dire.
But when you look at what jurors were actually seated, it appears that Lori must have figured out that women weren't going to be her best allies. Apparently, the prosecution believes men will be better for them because ultimately there's 13 men seated on this jury and 3 women. Now, that'll be whittled down to 12 who will actually be the jurors. And what that looks like, we'll find out in the future. But basically, the majority are men. And I'm guessing Lori's figuring she can flirt her way through with the men more easily than the women.
So let's just get to a conclusion here. When it comes to jury selection, a person like Lori Vallow Daybell, who is a narcissistic, religiosity, what were the other mental illnesses that she has been diagnosed with, representing herself, faces a significant disadvantage. The voir dire process is an opportunity to ensure that the jury is fair and impartial, but a defendant without legal expertise, especially one with personal biases clouding their judgment, could easily damage their own case. Her inability to control her emotions or properly navigate the complex legal questions involved in jury selection could seriously harm her ability to defend herself effectively in court. In the end, it's not just about being guilty or innocent. It's about being able to mount an effective defense.
During her trial in Idaho, there was no defense put up. None. And I have a feeling she might try this same strategy again in Arizona. And basically, the reason why I think that is one of her questions that she asked the jury, something to the effect of, if I don't put on a defense, can you still say I'm innocent if you don't think the prosecution proved I was guilty? This might be her only choice since she doesn't get to have any of her witnesses. All of them have refused, or the judge struck them from being able to testify. So she doesn't have a whole lot. And using herself as a witness opens herself up to cross-examination and a whole lot of trouble.
And Lori's decision to represent herself combined with her personality traits has made jury selection one of the many challenges in her already high-stakes trial. So, we'll see. It'll be interesting to see how this progresses. Don't forget to like and subscribe, and I will see you soon. See ya.